should be reported by defendants. Talking about indirect purchaser standing and their incentives and possibility for them to bring claims raises a question of aggregating claims, because we know that the indirect purchasers or small value claims are not usually able to organize their own case. So we have to have in place a mechanism that will make for them possible to go to the court. This is a sensitive issue in Europe because many people immediately refer to US class actions. Therefore, the entire debate in Europe is whether or not have class action or collective redress is a rather political issue and is normally led with many emotional arguments, which I will try to desensibilize, explaining that under the US law, a class action is a procedural mechanism governed by Rule 23 of the Federal Rules of Civil Procedure, which allows claims of a large group of plaintiffs or defendants to be adjudicated efficiently through all stages of litigation: motion, practice, discovery, trial, and potentially settlement. Class proceedings are available in private antitrust claims both in federal courts and most state courts. The reason as recently Supreme Court, as recently a judge in a Supreme Court decision, AT&T Mobility versus Conception, decided in April this year, argued why and how do we justify class actions. Judge was quoting a Carnegie decision saying, what rational lawyer would have signed on to represent the Conception in the litigation for a possibility of fee stemming from $30? So obviously there is no attorney who will take this, who will go to the court and file this class. So this claim. A federal plaintiff filing a class action must meet the class certification requirements under Federal Rule of Civil Procedure, Section 23. And these requirements are generally referred as numerosity, commonality, typicality, adequacy of representation. If those requirements are met, the class proponents must then satisfy additional rule that showing that questions of law or fact are shared among the members of the purported class, predominate over individual questions, and that the proposed class action would be superior to other methods of adjudication. In addition to this, I would like to stress that federal class action jurisdiction was recently expanded by Class Action Fairness Act, which makes it possible to bring into federal courts certain indirect customer antitrust class actions that had previously been litigated in state courts. The US class action system is an opt-out system. That means in any action in which a class is certified on the grounds of commonality of questions of law or fact and superiority of the class action procedure under Rule 23, plaintiffs must be given the opportunity to opt out. The notice provided to potential class members must specify the means for opting out and the deadline by which exclusion must be requested. When we come to the issue of shaping a European collective redress, we face many similar questions. The US law already provides an answer. So if we agree in Europe that we have a system with the choice for compensation of antitrust victims, then we have to agree that we need a mechanism for aggregating claims so that end consumers will not be left out. Such a process has a better chance of succeeding if the default position of class members is to opt out than to opt in. Violations of the antitrust laws ordinarily cause widespread injuries to many participants in the market. And in cases brought by overcharged purchasers, injuries suffered by any one of purchaser standing alone are usually too small to make independent pursuit of an individual damage claim cost effective. So the European Commission has launched a horizontal public consultation in order to identify common legal principles on collective redress and to examine how such common principles could fit into the EU legal system and into the legal orders of 27 member states. We have more examples of unsuccessful collective claims filed, for example, in the UK or French courts. And I would like to mention only one of those, which was attempted to be filed by the French consumer organization, which collected claims in its website against a French mobile telephone cartel, successfully collecting more than 17,000 such claims, whereby the court, when it came to this decision whether to allow the claim to proceed, came to the conclusion that the consumer French organization was not allowed to collect these claims because the class action system has not been recognized or is not existent under French law, and the claim was dismissed. So obviously the consumers were left out, and the possibility of class action is non-existent at the moment. In France, we know that some other member states do provide for collective mechanism, but we don't have any efficient and successful example in almost none of the member states. Obviously, one of the reasons is the imbalance between the costs and profits for submitting such a claim. When can an action for damages be brought? Limitation periods under the US law is set in Section 4B of the Clayton Act and provides for a 4-year statute of limitations. The period begins to run when a defendant commits an act that injures a plaintiff's business. Certain events may suspend the running of the statute of limitations. Under Section 5 of the Clayton Act, the running of the statute of limitations in respect to every private or state right of action shall be suspended during the pendency of government, civil, or criminal proceeding to prevent, restrain, or punish violations of the antitrust laws. Plaintiffs must bring suit within 1 year of the termination of the government action or within the original 4-year period, whichever is longer. Limitation periods in the EU vary, obviously, among the member states. Obviously, because of the public enforcement in the EU, you can bring an action only after the decision by the public authority has been made. This creates significant problems. For example, nobody has the courage to go to the court not knowing that there was an infringement in a case such as was, for example, Microsoft case, and having limitation periods not be long enough to allow you to go to the court, you are practically unable to file a damages claim. So therefore, the European Commission is suggesting a limitation period to extend beyond the proceeding of the competition authority for 2 years. What do you need to prove in your damages claim? Traditionally, in a civil damages claim, you have to prove infringement, harm, causality, and fault. Infringement issue raises a question whether there should be a binding effect of legal or factual determinations in prior proceeding, obviously in public proceedings. Should private plaintiffs be able to use government decisions and judgment as prima facie evidence of liability? In the US, Section 5 of the Clayton Act and the common law doctrine of collateral estoppel determine whether courts are bound in subsequent proceedings by legal or factual determinations in prior proceedings. And under Section 4A of the Clayton Act, Section 4 or 5 of the Clayton Act provides that the judgment or decree that the defendant has violated antitrust law shall be a prima facie evidence against such defendant in any action or proceeding brought by any other party against such defendant under antitrust laws. Under Section 5A of the Clayton Act, judgments or in prior Department of Justice actions are subject to collateral estoppel doctrine, while those from the Federal Trade Commissions are not. There I have to say the trial court retains broad discretion to decide whether collateral estoppel doctrine would be fair in any particular case. In the EU, we know that European Commission is suggesting binding effect of prior public decisions made by public enforcement, and both, meaning the European Commission's decisions which are binding already and the decisions made by national competition authority. Currently, under of the Member States Act, only German Competition Act provides for such a binding effect. Harm or antitrust injury is an element which means that the plaintiff must prove an injury of the type the antitrust laws were intended to prevent, and that flows from that which makes defendants' acts are unlawful. The effect of injury must be proven with a reasonable degree or certainty. Causality must be proved, meaning that, which is also a case in the civil damages claims, that there is existence of causal connection between the defendant's antitrust violation and harm. And this brings me to harm, which has been shown that is one of the most difficult proofs to be made in the damages claims.